there, thanks for joining me again. In this video, I would like to discuss misrepresentation. Misrepresentation can be direct and indirect. Direct means you intentionally misrepresented information to Citizenship Immigration Canada. For example, if you lie to immigration about your legal name or your date of birth or something like this. So that could be direct, where you intentionally and knowingly informed immigration about an information and then immigration finds out. There could also be indirect misrepresentation. Indirect means you didn't know that it was misrepresentation, or you didn't do it knowingly or intentionally. Regardless if it's indirect or direct misrepresentation, it's still misrepresentation nonetheless. Meaning the consequences of both can be extreme and it can be the same. So just because you did something that you didn't know was technically misrepresentation doesn't mean that the officer will say, okay, that's fine, I will, not charge you with misrepresentation, or I will forgive you, or whatever it may be. So the consequences of misrepresentation is essentially the same. Another example of indirect misrepresentation is when an individual puts that they're single when meanwhile they're in a common law relationship. So common law is when you reside together with your partner for 12 months or more. So there could be a fine line where you could technically also be single because you can see yourself as boyfriend-girlfriend and not necessarily a common law relationship. So if you are living with someone for 12 months or more and you see yourself as boyfriend-girlfriend and you want to check off single, put a cover letter and explain your situation to the officer so you don't get charged with misrepresentation. A lot of times when we see clients come through our doors, it's about misrepresentation on a possible past application that they've submitted. So information that they've submitted in a past application doesn't necessarily match with the one that they've submitted this time. So you want to make sure that whatever applications you've submitted ever in the past, it will match the information that you're going to present to the officer this time. This goes from anything from name, date of birth, employment history, travel history, your relationship status, everything. You want to make sure it matches. Sometimes also what happens is you filed an application in the past and you notice that you made a mistake in the past application, that you disclosed something to the officer that was actually wrong and you want to fix that. That's fine. You can be proactive and fix that information, inform the officer that, I had indicated on this application that I was working for this company from this date to this date. However, I made an error. It's actually from this date to this date. So if you are being proactive and informing the officer in advance that this is an error that you made, that will be fine. You're not going to be charged with misrepresentation by voluntarily disclosing that you've made an error on a past application. So that will be fine. So making sure that you understand misrepresentation can be direct and indirect. Now, there are several consequences that can happen with misrepresentation. For starters, your application can get returned to you. Another can be a rejection that they have found out that you've not represented yourself accurately, and the application can get rejected. Also, you can get a ban, which means you can get a ban from entering Canada. Usually the maximum I've seen a ban is 5 years. And what that means is if you get a ban, that means you are not allowed to enter Canada during that time. You cannot apply for any other application. It's not like you can apply for a document to overcome that ban. Once the ban is issued, that means it's issued, and that for the validity of that ban, no application whatsoever, whether it's a temporary document or a permanent document, will not even be reviewed. So should you receive a ban because of a direct or indirect misrepresentation, please contact us immediately, and potentially we can contact the officer and ask the officer for reconsideration. We have been very successful in the past of lifting this ban by requesting reconsideration to the officer because they either didn't know all the facts or they misunderstood some of the facts, and the officer acknowledged it and then removed that ban. However, If a lot of time elapses and you contact us, let's say 6 months after you receive the ban, it's going to be extremely difficult for us to ask that officer for reconsideration. So the sooner we request the reconsideration once you get that ban, the higher chance of success for your application. If you're in this particular situation, please give us a call immediately and we'd be more than happy to answer all your questions. And remember, at Akrami & Associates, there's always a way. We look forward to hearing from you.